He was smiling when I walked in, not a nervous smile, not the kind a man wears when he knows he's done something wrong and is trying to cover it. This was the other kind, loose, comfortable, the smile of a man who had already decided how the day would end. He was leaning toward his attorney, saying something low, and the attorney laughed. Derek always had that effect on rooms. He knew how to make people feel like they were in on something. He didn't recognize my shoes. I've had these same black pumps for 6 years. Wore them to our anniversary dinner in 2019. Wore them the morning I argued my first federal motion. He never once looked down. That's the thing about a man who stops seeing you. He stops seeing all of you. The details go first. Then the rest follows. I want you to hold that image, Derek laughing in the third row, completely at ease, while I stood 20 feet behind him in a robe he didn't know I owned. Because in about 4 minutes, a bailiff was going to call the room to order. And the name they were going to call was mine. Before we go any further, what time is it? Where you are right now, drop your time and your country in the comments. I want to know who's here for this. I grew up in a house where the women cooked on Sundays and the men talked about money. Not because anyone sat us down and explained the rules. It was just the way the air moved in those rooms, the way my aunts would drift toward the kitchen after grace, the way my grandfather held the table like a court he was presiding over. I watched all of it. I watched, and I filed it away the way I filed everything quietly, completely, without anyone knowing I was taking notes. My mother was the sharpest person I have ever known. She could read a room in 4 seconds flat, could tell you who was lying, who was scared, who was performing confidence they didn't own. She never went to law school. She never needed to. But when I was 11 years old, she watched me talk my way out of a punishment I absolutely deserved. And she looked at me with something that wasn't quite pride and wasn't quite warning. And she said, "Ava, you need to do something with that mouth before it gets you into a room you can't get out of." I went to Howard at 17 on a partial scholarship and a lot of nerve. Law school at 22. Clerked for a federal judge in D.C. at 25. Judge Miriam Okafor, the kind of woman who corrected your grammar in the margins of your briefs and expected you to thank her for it. I did. I thanked her every time. I was on track for an appointment by 31. Then I met Derek. I want to be careful here, because the easy thing would be to say, he derailed me. That's the version that makes me the victim and him the obstacle, and that version is too simple to be true. The truth is, I made choices. I made them with full information and full agency, and I would make some of them again. What I would not do again is make them quietly in the dark for a man who never once asked what I was giving up. We met at a fundraiser for a city council candidate in D.C. Derek was in commercial real estate, already doing well, the kind of well that looks like confidence. Before you understand, it's mostly leverage. He was funny. He was present in a way that men at fundraisers rarely are not working the room, just standing in it talking to me like I was the only interesting thing that had happened to him all night. I was 30, and I was tired of interesting men who disappeared after 3 weeks, so I let myself pay attention. We dated for 2 years, moved in together. He proposed at a restaurant in Georgetown, nothing performative, just a small box slid across the table between the entree and the dessert, and him watching my face the way you watch a door when you're not sure what's on the other side. I said yes. I meant it. The move to Atlanta was his idea, and I agreed to it because his business was expanding and because I believed with the particular confidence of a woman who has never been wrong about herself before that I could rebuild my career anywhere. I had the credentials. I had the reputation. What I did not fully account for was how long rebuilding takes, or how much of that time I would spend managing Derek's idea of what a wife was supposed to look like. It started small, the way these things always do. He didn't like when I worked late. Not in an aggressive way, just a persistent, low-grade way. The kind of dissatisfaction that expresses itself as about sighing and distracted answers and a particular silence at dinner that you learn to read like weather. I adjusted. I came home earlier. I took fewer cases in the first year. I told myself it was temporary, that once we were settled, once he saw I could do both, the tension would ease. It eased. For a while. I passed the Georgia bar on my first attempt. Took a position with a mid-size firm downtown doing civil litigation. It wasn't the federal track I'd been on, but it was real work, and I was good at it. In 3 years, and a colleague mentioned my name to the State Judicial Nominating Commission. I went through the process quietly. Told Derek it was exploratory. Didn't mention the appointment when it came through. That was my first mistake. Not the appointment, the silence around it. I told myself I was protecting us from a conversation we weren't ready to have. What I was actually doing was learning to exist in 2 registers at once. The woman who came home and made dinner and asked about his day. And the woman who showed up to Fulton County Courthouse 3 mornings a week and presided over cases that would outlast both of our names. I kept those 2 lives in separate compartments, the way you keep documents in separate folders. Clean, organized, airtight. The tightness, it turns out, was the problem. Derek never asked about my work in any real way, not after the first year. He asked the way you ask someone about a hobby. How was it? Was it fine, good? And then moved on to what he actually wanted to talk about. I stopped offering details. He stopped noticing I'd stopped. And somewhere in that mutual silence, I became in his mental architecture a woman without a professional life, worth accounting for. I know this because of what he said to his attorney 14 months later. But I'm getting ahead of myself. What I want you to understand before we get to the fundraiser and the text messages and the morning I sat in my car in the courthouse parking garage for 11 minutes before I could make my hands stop shaking. What I want you to understand is that I was never invisible. I just let him think I was. And there is a difference. A very important difference. The difference is the thing that kept me standing when everything else came apart. The first sign was a Tuesday in October. Not a dramatic Tuesday. Not a Tuesday with weather or an argument or anything you could point to later and say there, that was the moment. It was the kind of Tuesday that only becomes significant in retrospect, when you're lying awake at 2 a.m., assembling a timeline you didn't know you were living through. Derek had a work dinner. He mentioned it. Sunday mentioned it again, Monday morning, while pouring coffee the way you mention something you expect no questions about. Client from Charlotte. The Buckhead Diner. Shouldn't be too late. I said fine. I had a motion to finish anyway. He kissed me on the cheek and left, and I sat back down at my laptop and worked until 9 and heated up whatever was left in the refrigerator and went to bed. He came home at 12:47 a.m. I know the time because I'd been asleep for maybe an hour. And I looked at my phone when I heard the garage door. I didn't say anything. He moved quietly through the house, the way people move when they think they're being considerate, and I lay there and listened to the particular sounds of a man who was very deliberately not making noise, and then I went back to sleep. I didn't think about it again for 3 weeks. The second sign was his phone. Derek had never been precious about his phone. In 11 years of marriage, I had borrowed it to look up directions to show him a photo I'd already sent to my own phone to settle arguments about song lyrics at dinner. He handed it over without thinking. It was such a consistent, unremarkable thing that I had stopped noticing it entirely the way you stop noticing a piece of furniture that has always been in the same corner. So when I reached across the kitchen island one Saturday morning to show him a restaurant I'd found for his mother's birthday dinner, and he picked the phone up before I could touch it, not snatched it, nothing so obvious as that, just lifted it and turned the screen down, in one smooth motion I noticed. Not because the gesture was large, because it wasn't. It was the smallest possible version of the gesture. Practiced. The kind of small you only get after repetition. I finished making my coffee. I asked him what he thought about the restaurant. He said it looked fine. I said I'd make a reservation. He said, "Great." We had a perfectly normal Saturday morning. But my mind had already opened a folder and placed something inside it. October became November. Derek traveled more Charlotte again, then a development project in Nashville. Then a conference in Miami he mentioned 4 days before he left. I was busy. 3 cases running simultaneously, a judicial conference in Savannah that took me away for a Thursday and Friday a motion hearing on a Monday morning that I had to prepare for over the weekend. We moved around each other in the house like 2 people sharing an office. Polite, functional, occupying different time zones that happened to use the same kitchen. I noticed he had started deleting his call log. I noticed because I borrowed his phone one evening to call my mother. Mine was charging across the house. And I didn't want to walk. And when I opened the call screen out of habit, the way you glance at a table before you set something down, it was empty. Completely empty. A man who gets 30 business calls a day, and the log is empty. I put the phone to my ear and called my mother, and we talked for 12 minutes about her neighbor's fence dispute. And when I handed the phone back to Derek, I watched his eyes go to the screen for just a half second before he slipped it into his pocket. I didn't say anything. There is a particular skill you develop as a judge. Maybe as a woman, maybe as both the skill of receiving information without reacting to it in the moment. You learn to let the information land, to absorb it fully, to feel the complete weight of it, and then to file it without showing the filing. Derek had watched me do this in arguments for years, and he called it coldness. He would say, "You're doing the thing again, Ava, where you just shut down." And I would think, I am not shut down. I am processing. There is a difference. But I never said that either, because explaining the difference would require explaining myself, and I had spent 11 years slowly, incrementally deciding that wasn't worth the energy. What I filed in November was this: something is wrong. I do not yet know what it is. I will not move until I do. December brought the work party. Derek's firm held their annual client appreciation event at a rented space in Midtown. Exposed brick-high ceilings, the kind of venue that costs enough to imply success without being so expensive it embarrasses the clients who are struggling. I wore a navy dress I'd had for 2 years. Derek wore the charcoal suit he wore to everything. We drove together, and we were good at being together in those settings we had had, 11 years of practice. And by the second drink, he had his hand at the small of my back and was introducing me to people the way he always did, with a kind of proprietary warmth that I had once found romantic and had more recently started to examine. A man named Curtis found me near the bar while Derek was across the room. Curtis was a contractor, did? Commercial Interiors had worked with Derek's firm on a project 2 years prior. He was easy to talk to. We talked about Atlanta traffic and then about a restaurant that had just closed in Ponce City Market, and then in that sideways way that conversations drift at open bars about Derek. "He seems happy," Curtis said. "Good energy tonight." I agreed. "Derek's always been like that," Curtis said, "even when things are complicated." He smiled into his drink, the smile of a man who has said more than he meant to. "Him and his girl? I shouldn't." He stopped, reset. "Good guy, though. Derek's a good guy." I looked at Curtis for exactly 2 seconds. "He really is," I said. And then I excused myself and went to find the bathroom and stood at the sink with both hands flat on the cold porcelain and let myself feel for exactly 90 seconds everything I had been filing. Then I turned off the faucet, dried my hands, and went back to the party. Derek drove us home. He talked about a deal he was close to closing. I asked the right questions. We went to bed. I lay in the dark, and I thought about the phone. The call log, the Tuesday in October. The restaurant I had suggested for his mother's birthday that we never ended up going to. The folder was getting full. I found out on a Wednesday morning in January in my own kitchen with a cup of coffee I never finished. I want to be precise about this, because precision is the only thing that keeps a memory like this from becoming a story you tell yourself instead of something that actually happened. The coffee was dark roast. The mug was the one Derek had brought back from a conference in Chicago, white ceramic. A skyline printed on the side, a gift he gave me, the way people give things when they're not thinking about the recipient at all. I was standing at the island, reading a brief on my tablet, still in the clothes I'd slept in, when his phone buzzed against the granite. He was in the shower. The notification was from a number saved as S. Just the letter, the way you save a contact when you want it to be invisible, but you're too attached to delete it entirely. The preview showed 4 words before the screen locked. Miss you last night. I stood there. I read it again. I set my coffee down. His phone locked after 30 seconds, and the screen went dark. I picked up my tablet. I went back to the brief. I read the same paragraph 4 times, without understanding a single sentence. Then I set the tablet down too. And I stood very still in my kitchen. And I did the thing I had trained myself to do. I let the information arrive completely, without resistance, without the noise of immediate reaction. I felt it move through me the way cold water moves when you drink too fast. All the way down. Derek came out of the shower 20 minutes later in his work clothes, smelling like the cedarwood soap he'd used for as long as I'd known him. And he poured himself a coffee and asked if I'd seen his good cufflinks. And I told him they were on the nightstand right side, and he said thanks and kissed me on the top of my head the way a man kisses a piece of furniture, and walked out the door. I listened to his car back out of the driveway. Then I went to get his phone. He'd left it on the charger by the coffee maker, a mistake he'd never made before, or maybe a mistake he'd been one step away from making for months. I picked it up. His passcode was our anniversary date, which told me something important. He wasn't afraid of me looking. He'd never imagined I would. The conversation with S went back 4 months. I read it the way I read a deposition, systematically, without rushing, annotating in my mind. Her name was Sienna. She was 31. She worked in marketing at a firm 2 buildings from Derek's office. They had met at a coffee shop in September. He'd told me he was having lunch with a client. Their first conversation in the thread was professional. By week 3, it was not. By November, it was something I will not detail here because the details are not the point. The point was a message from Derek, dated November 14th, a Sunday afternoon. I had been in the garden. I remember because I'd come in with dirt on my knees, and he was on the couch watching football. And he hadn't looked up. The message said, "She's been on this law thing lately. I don't even know what she does half the time. Honestly, Cy, she's just the placeholder until I figure out the next move." The placeholder. I read the word 3 times, not because I needed to, because I wanted to be certain I was not misreading, that I was not inserting injury where there was only carelessness, that the word meant what I understood it to mean, that in the internal accounting of my husband's life, I was a temporary entry, a line item pending deletion. I set the phone back on the charger. I went to the bathroom, and I washed my face with cold water. I looked at myself in the mirror for a long time. Not with grief. Grief would come later, at its own pace. In its own time, and I would let it. What I felt in that moment was something older and quieter than grief, something that lived below the emotional register entirely. I recognized it. I had felt it once before at 26, sitting across from a senior partner who told me I was talented, but not quite ready. And I had understood in the same wordless way that the problem was not my readiness. The problem was his assessment, and that those were 2 entirely different things. I knew what I was going to do. Not the specifics, those would come in stages, carefully, the way you build a case. Not the timeline that depended on variables I didn't yet control. But the orientation, the direction, the particular quality of stillness that is not passivity, but its precise opposite. I called my attorney that afternoon from my office. Not a friend, not a colleague. a woman I had never appeared before who practiced family law out of a firm in Sandy Springs, who had been recommended to me 2 years earlier by a judge I trusted before I ever thought I would need her. I had kept the name in my phone under M. Holloway Ref. I had never examined why I kept it. Her name was Margaret. She was direct and unhurried, and she asked me exactly the questions she needed to ask. I answered all of them. At the end of the call, she said, "How long do you need?" I said, 60 days. She said, "I'll have the draft ready in 2 weeks." I hung up. I sat at my desk. Through the window, I could see the parking lot of the courthouse 4 stories below. A woman in a gray coat was walking toward the entrance carrying a stack of folders, walking the way you walk when you're late, but you've decided not to run. I watched her until she went through the doors. Then I opened the brief I hadn't finished that morning, and I got back to work. Derek came home that evening, and I had made dinner. And we sat across from each other. And I listened to him talk about the Nashville project. And I asked the right questions, and I cleared the plates. And we watched television for an hour. And I went to bed and I slept, genuinely slept better than I had in 4 months, because the folder was closed. And the case had begun. I've always believed that the most dangerous thing a woman can do is let a man believe he already knows the ending. Not because it's cruel, because it's efficient. Derek believed he knew the ending. I could see it in the way he moved through the house in those 60 days, looser than he'd been in months, lighter, the particular ease of a man who has made a private decision and is simply waiting for the calendar to catch up. He was kinder during that period, which was the detail I found most clarifying. He remembered to ask about my day. He suggested we try a new restaurant in Virginia Highland on a Friday night. He bought flowers, once grocery store flowers, the kind that come in plastic wrap, but still, he was performing the marriage with more attention than he'd given it in years, because he had already left it in the part of his mind that counted. I let him perform. I matched his energy exactly. Warm, but not effusive. Present, but not clingy. The kind of wife who seems settled, untroubled. The kind of wife a man feels comfortable leaving because she will clearly be fine. I had always been good at this, at giving people the version of me they were most comfortable receiving. It had been a liability in the marriage. In those 60 days, it became an asset. Margaret sent the draft petition on a Thursday evening. I read it at my desk at the courthouse after my last hearing of the day, in the particular quiet of a building that is mostly emptied out. She was thorough. Everything I had documented: the accounts, the property, my professional history, the years I had contributed to the household infrastructure, while Derek's business expanded on the stability I quietly provided. It was all there, organized, precise, without sentiment. I made 2 small edits and sent it back. Then I opened my bottom drawer and took out the robe. I had started keeping it at the courthouse full-time in November, after Derek had once walked into my home office without knocking while I was on a call with a clerk about a scheduling matter. I had covered the receiver and looked at him, and he had said, "Sorry, didn't know you were on the phone," and walked back out. And I had thought, not yet. Not yet. I moved the robe the following Monday. Black with the gold piping along the collar, the weight of it familiar in a way that I didn't have words for, the way certain things become extensions of you before you've thought to name them. I hung it on the back of my office door, and I looked at it for a moment, and then I went back to work. The filing happened on a Tuesday. Margaret handled it. Derek was served on a Thursday morning at his office, as I had requested, rather than at home. Margaret had advised against it. I overruled her. I had my reasons. I know the moment he was served because he called me 47 minutes later. I was on the bench. My clerk slipped me a note during a recess. "Your husband called. Said it's urgent." I folded the note once and set it beside my water glass. When the recess ended, I went back on the record and finished the afternoon. I called him back at 5:20 from my car in the parking garage. He was not shouting. Derek rarely shouted. He was doing the thing he did when he was genuinely destabilized, talking fast and precise, like a man trying to assemble furniture without the instructions, picking up pieces and setting them down. He said he didn't understand. He said we could talk about this. He said he didn't know where this was coming from. He said the word blindsided twice. I said, I know this is a surprise. He said, Ava. I said, Margaret Holloway is my attorney. You should call yours. There was a pause, a long one, the kind that has a texture to it. He said, You already have an attorney. I said yes. Another pause. How long have you been planning this? I looked through my windshield at the concrete pillar in front of me. Someone had taped a lost dog flyer to it. A brown terrier mix named Biscuit, missing since December. A phone number in large print at the bottom. Take care of yourself, Derek, I said. And I ended the call. He retained counsel within 48 hours. A partner at a downtown firm, aggressive, expensive, the kind of attorney you hire when you want to send a message before the first filing. His name was Grant Hollister. I knew of him. He knew of me, though not in the context he was about to. Grant's first move was a financial disclosure request, sent so broad it was nearly satirical, every account, every asset, every income source for the past 7 years. Standard intimidation tactic. The implication being we will bury you in paperwork until you agree to something unfavorable just to make it stop. Margaret called me after she received it. She was composed, but I could hear the particular calibration in her voice that meant she was choosing her words. She said, Ava, I want to make sure we're aligned on full disclosure. I said, we are. She said, everything. I said, everything. A beat. All right, she said. Then I'll prepare the response. I had disclosed everything to Margaret in our first call. My appointment, my salary, my full professional history in Atlanta. She had absorbed it without comment, the way a good attorney absorbs information completely and without theater. She had asked one question, does he know? I had said no. She had said, and you want to keep it that way until disclosure? I had said yes. She had not asked why. That was one of the things I respected about her. The disclosure response went out on a Monday. It was 43 pages. It included my judicial appointment, my federal salary grade, my full case history, 3 letters of commendation from the chief judge of the Northern District of Georgia, and a professional photograph taken when I was sworn in, me and the robe hand on the Bible, the kind of image that takes up space. I imagined Grant Hollister opening that file. I allowed myself exactly 1 moment of satisfaction, the length of a single breath. Then I moved on. Derek did not call again. His communications came exclusively through Grant after that which was appropriate, and also told me what I needed to know about the temperature on his side. I started carrying the robe in my car again. Not for any strategic reason, just because it felt right to have it close. The way you keep an umbrella, even when the forecast is clear, not from pessimism, but from a kind of self-knowledge about what kind of weather finds you. 3 weeks before the hearing, I ran into a colleague in the courthouse elevator. Judge Nathaniel Reeves' federal bench had been on the court for 20 years, the kind of man who speaks in full paragraphs and means every word. He asked how I was. I said, managing. He nodded. He looked at the elevator doors. Then he said, without looking at me, You know, I've watched a lot of people come through difficult things in this building. The ones who do it well, they don't try to make it smaller than it is. They just make themselves big enough to carry it. The doors opened. He walked out. I stood there for a moment longer than necessary. Then I straightened my shoulders and walked to my courtroom. Grant Hollister filed the amended petition on a Monday morning, and I read it that evening at my kitchen table with a glass of water and the particular quality of attention I reserve for things that are designed to cause harm. It was precise work. I will give him that. The central argument was dependency. 11 years of marriage and Derek's legal position was that I had been financially reliant on him for the majority of it. That my intermittent employment had been supplementary at best, that the lifestyle we maintained had been built primarily on his income and his professional momentum, and that any asset division should reflect this reality. The word intermittent appeared 6 times. I counted. There was a section on the Atlanta move that reframed my decision to follow Derek as evidence of his financial support, as if I had been carried here, installed, maintained. There was a paragraph about the years I had reduced my caseload that described them in Grant's careful language as a period of professional dormancy from which the respondent has not meaningfully recovered. Professional dormancy. I set the document down. I picked up my water glass. I drank. Then I picked the document back up and finished reading it, because the worst thing you can do with a document designed to make you feel small is stop reading it before you've understood exactly what it's trying to do. Margaret called the next morning. "I've reviewed it," she said. "It's aggressive." "It's a strategy," I said. "It's also mostly fiction." "Most strategies are," I said. "What's our timeline?" She ran through it. The hearing was set for 6 weeks out. Discovery was ongoing. She had already begun preparing the counterfiling, which would include my full employment record, salary history, and professional standing. She said it with a steadiness that I appreciated, not reassurance, not comfort. Just the clean transmission of information between 2 professionals who understood the terrain. What I did not tell Margaret was that the filing had done something to me that I had not anticipated. Not broken me. Nothing so dramatic. It had clarified something. There is a kind of anger that is useful, not hot anger, not the kind that makes you say things in parking lots that you regret at 3 a.m., but the cold architectural kind, the kind that reorganizes itself into precision. I had felt it before in courtrooms when opposing counsel tried something I found genuinely contemptible. It does not feel like fire. It feels like a room getting very quiet. The room was very quiet. Derek called me on a Wednesday. Not through Grant, directly from his cell at 7:14 in the evening, while I was grading a clerk's draft opinion at the kitchen island. I let it ring 4 times before I answered. Old habit. He wanted to talk about the house, not the settlement broadly. Specifically the house. The one we had bought together 7 years ago in Cascade Heights, the one I had spent 2 weekends painting the kitchen of. Because we couldn't agree on a contractor, the one with the magnolia tree in the backyard that bloomed every March without fail. The one that contained in its walls and its light and its particular smell on Sunday mornings 11 years of a life I had genuinely tried to build. He wanted to list it, sell it, split the proceeds. He said it with the tone of a man proposing something reasonable, the tone of a man who has rehearsed reasonableness, and I sat with the phone against my ear. And I looked at the kitchen island where I was working, and I thought about the magnolia tree. I said, "Have your attorney contact mine." He said, "I'm trying to talk to you, Ava." I said, "I know. Have your attorney contact mine." A silence. Then he said something I had not expected. He said, "You know none of this had anything to do with you not being enough." I held the phone very still. It got complicated, and I handled it wrong, and I'm not trying to excuse it. I just don't want you to think. Derek. He stopped. I have never, not once in 11 years, thought the problem was that I wasn't enough. I said it without heat, without anything you could call emotion, technically. That is one thing you never managed to make me believe. Another silence, longer this time. He said, "Okay." I said, "Good night." I hung up. I went back to the clerk's draft. There was a problem with the reasoning in paragraph 4 that needed addressing before morning. The weeks that followed had a particular texture to them. I worked I presided. I came home, and I prepared. And I moved through the house that was not yet not mine, with the careful attention of someone who knows a season is ending. I started to notice things I'd stopped noticing, the way the light came through the kitchen window at 6 in the morning. Orange and flat and honest, the way the floorboard outside the bathroom creaked on the left side, only the way the magnolia tree was already starting to bud in February ahead of schedule. I let myself notice. I did not let myself linger. 2 weeks before the hearing, Grant filed a supplemental motion requesting an independent financial audit of my alleged professional income. The language was his, and it was designed to cast doubt without evidence, the legal equivalent of raising an eyebrow in front of a jury. Margaret responded within 48 hours, attaching documentation so thorough it was almost punitive. I had approved every page. The motion was denied. 1 week before the hearing, I received the judicial assignment notification. It arrived as a routine administrative email from the court scheduling office, the kind of email that fills your inbox 15 times a day when you work in a courthouse procedural templated easy to miss. I almost did miss it. I was between hearings, standing in the hallway outside courtroom 7B, scrolling through my phone, while my clerk talked to me about a rescheduling conflict on a different matter. I read the subject line twice. Case reassignment, Fulton County Civil Division. Honorable A. Reeves, temporary recusal, replacement assignment. Honorable A. My name. I stopped walking. My clerk said, "Judge, you okay?" I looked up. The hallway was the usual kind of busy attorneys with rolling bags, a family waiting on a bench outside a courtroom, a bailiff eating a sandwich by the water fountain. Everything ordinary. Everything exactly as it always was. "Fine," I said. "What were you saying about the rescheduling?" She repeated it. I answered. We walked back toward my chambers. I did not tell her about the email. I did not tell anyone. That evening, I went home, and I sat in the kitchen in the dark for a while. Not distressed, not elated, just sitting with the specific weight of what was about to happen. The magnolia tree was visible through the back window, the buds tight and pale in the February dark, not yet ready, just on the edge of becoming. I thought about Derek's face, not with satisfaction, not yet. With something more complicated. 11 years. The fundraiser in D.C. The box slid across the table. The way he had once early on, when I was sick with a February flu, sat on the edge of the bed and read to me from a novel I'd been meaning to finish reading. Badly stumbling over words, but reading for 2 full hours because he didn't know what else to do. I let myself have that memory. All the way through. Then I went upstairs. I laid out my clothes for the morning. I set the robe by the door, and I went to sleep. The morning of the hearing, I woke at 5:03 a.m. without an alarm. This is not unusual for me. My body has kept judicial hours for so long that it no longer requires instruction. It simply begins the way a courthouse begins, before the public arrives, before the noise in the particular stillness of a building that is already preparing for what it was built to do. I lay still for a moment in the dark, and I listened to the house. The refrigerator cycling on in the kitchen below. A car passing on the street outside. The magnolia tree doing whatever magnolia trees do in the hour before dawn. Derek had moved out 3 weeks prior. He was staying at a corporate apartment in Buckhead. I knew this because Margaret knew it, because his attorney had provided the forwarding address for correspondence. The house had a different sound without him in it. Not empty exactly. More like a room after a long meeting has ended, the furniture still arranged for conversation, the air still carrying the faint pressure of everything that was said. I made coffee. I sat at the kitchen island with both hands around the mug, and I did not read anything, did not check my phone, did not review notes. I had reviewed everything I needed to review. What I needed this morning was not more information. What I needed was to arrive. I showered. I dressed carefully the black suit I wore when I wanted to be taken seriously, without announcing that I wanted to be taken seriously, the black pumps I had owned for 6 years, small pearl earrings my mother had given me when I passed the bar. Nothing excessive, nothing that needed explaining. I put the robe in its bag, and I put the bag over my shoulder, and I walked out of the house, and I got in my car. The courthouse on a Thursday morning has a specific smell, cleaning fluid and paper, and something older underneath something that is soaked into the walls over decades of arguments and decisions, and the particular human sediment of people bringing their worst problems to a public room and asking strangers to adjudicate them. I have always found it clarifying. Some people find hospitals clarifying, or churches. For me, it has always been the institutional weight of a building that exists specifically to resolve what cannot be resolved anywhere else. I took the elevator to the 7th floor. My clerk, a second-year law student named Patricia, who had been with me for 8 months and had the instincts of someone twice her age, was already at her desk when I arrived. She looked up. She started to say something about the docket. I said, "Give me 10 minutes." She nodded and went back to her work. I went into my chambers. I closed the door. I set my bag on the desk, and I took out the robe. And I held it for a moment, the weight of it, the fabric, the specific authority it carried, that had nothing to do with the person inside it, and everything to do with what the person inside it had agreed to be accountable for. I put it on. I stood at the window that looked out over the parking lot. The morning was gray and dry, the Atlanta winter doing its half-committed thing, not cold enough to be dramatic, not warm enough to be forgiven. I could see cars pulling in, people walking toward the entrance carrying briefcases and folders, and coffees doing the ordinary work of arriving. I thought about something Judge Okafor had told me during my clerkship, during a week when I had made a procedural error I was struggling to move past. She had been unsentimental about it. She was always unsentimental. But at the end of the conversation, she had said, "Ava, the robe doesn't make you infallible. It makes you accountable. Those are very different things. Never confuse them." I had not confused them. Not then, not now. At 8:47 a.m., Patricia knocked and opened the door 3 inches. "Parties are assembled, Your Honor. Plaintiff's counsel has requested 5 minutes before you take the bench." Plaintiff's counsel, Grant Hollister, requesting 5 minutes, which meant he had seen my name on the assignment notification and wanted a conversation before things became official. A reasonable request. A predictable one. The kind of move you make when you are trying to negotiate the shape of what's coming before it arrives. I said, "Denied. We'll proceed on schedule." Patricia's expression did not change. "Yes, Your Honor." She closed the door. At 8:59, I picked up my notes. At 9:00, I walked out of chambers and down the corridor toward courtroom 7, past the water fountain and the bulletin board, and the framed photographs of former chief judges, past all the ordinary furniture of a building that had been deciding things for longer than I had been alive. The bailiff outside the courtroom door straightened when he saw me. He was young, mid-20s, new to the floor. I had seen him twice before. His name was Officer Trent, according to his badge. He said, "Good morning, Your Honor." I said, "Good morning, Officer Trent." He opened the door. I stopped just inside the threshold, in the narrow space between the door and the bench, in the shadow that falls there, when the overhead lights are on, and the windows are not yet fully bright. From here, I could see the room without being seen by it. The gallery with its rows of wooden benches, mostly empty. A Thursday morning civil hearing draws no audience. The 2 tables facing the bench. Margaret at the left table, her back straight. Her files organized in the particular order I recognized as her system. And at the right table, Grant Hollister in a charcoal suit and his client beside him, Derek. He was turned sideways in his chair, speaking to Grant in a low voice, his elbow on the table, his body loose, the posture of a man who has been told things are going his way. He was wearing the navy tie I'd given him for his birthday 3 years ago. He did not know he was wearing it. He would not have chosen it if he'd known. He was smiling at something Grant said, the same smile from the beginning of this story. Comfortable, decided, the smile of a man who had already written the ending and was simply waiting for the room to catch up. I watched him for exactly 4 seconds. Then I stepped forward and the bailiff said in the flat, procedural voice that has called rooms to order in this building for as long as there has been a building. All rise. The Honorable Ava. And the room rose. And Derek turned around. I did not look at him immediately. I walked to the bench the way I always walk to the bench, without ceremony, without performance, with the particular economy of movement that says this is a working room and we are here to work. I set my notes down. I adjusted the microphone. I looked at the docket sheet Patricia had prepared. Then I looked up. Derek was standing with the rest of the room. His mouth was open approximately a 1/4 inch. His hand was on the back of his chair in a way that suggested the chair was holding him rather than the other way around. Grant Hollister, to his credit, had recovered faster. He was already composing his face into the expression of a professional who has encountered an unexpected development and is processing it within acceptable parameters. Derek had not recovered. He was looking at me the way people look at something that cannot be what it appears to be. The specific quality of a mind trying to reconcile 2 images that cannot both be true. The woman who had made his coffee that morning 11 months ago, and the woman behind the bench in the robe that said something about power that no amount of amended petitions about professional dormancy could touch. I let the silence sit for exactly as long as it needed to. Then I said in the voice I use in courtrooms, the voice that is mine, but is also larger than mine, that carries in it everything the robe carries. Good morning. Please be seated. Everyone sat. Derek sat last. I looked down at my notes. We are here today in the matter of the dissolution of marriage, I said. Before we proceed, I want to address the motion for reassignment that was communicated to my clerk this morning. I looked up. Grant was on his feet. Your Honor, he said, my client respectfully submits that given the relationship between... Counselor. I said it quietly. He stopped. I'm going to let you finish that motion, but I want you to be precise. What is the legal basis for the recusal request? A pause. Conflict of interest, Grant said. Given the personal relationship between Your Honor and the respondent. The respondent, I said, is my client's ex-spouse. I am the assigned judicial officer. The question before this court is whether a personal relationship that is itself the subject of the dissolution proceeding constitutes grounds for recusal under Georgia Code Section January 8, 15. I looked at him steadily. Do you have case law? Another pause, longer. We would request time to... You had time, I said. The assignment was posted yesterday at 4:32 p.m. It is now 9:04 a.m. You had 16 hours and 32 minutes. I looked at the clock on the wall, then back at Grant. Do you have case law, counselor? The room was very quiet. Grant said, we would like to note our objection for the record. I said, so noted. Motion denied. We'll proceed. I did not look at Derek, but I heard him. A sound, not quite a word, not quite a breath, something between the two. The sound a man makes when the floor does something floors are not supposed to do. I picked up my pen. Counselor Holloway, I said, you may proceed. There is a rhythm to a courtroom that most people never learn to feel. It is not the rhythm of drama, not the way it looks in films with their swelling music and their perfectly timed revelations. The rhythm of a real courtroom is slower and more technical, and in its own way, more merciless. It proceeds by increments. Statement-response ruling. Question objection sustained or overruled. The architecture of it is designed specifically to prevent the kind of emotional flooding that makes human beings unreliable narrators of their own experience. That is the point. That has always been the point. I had presided over 341 hearings in my career. This was 342. Margaret opened with a financial disclosure summary, clean, chronological, without editorializing. She walked through my employment history in Atlanta with the same tone she might use to read a grocery list, which was exactly correct. The facts required no embellishment. 7 years on the Georgia bench. Federal appointment, Northern District, 3 years running. Annual salary that placed me, as she noted without inflection, in the top 4% of earners in Fulton County. I watched the room as she spoke. Grant was writing. Fast, the kind of writing that means recalculation rather than note-taking, a man revising a strategy in real time, crossing out assumptions, trying to locate solid ground in terrain that had just shifted entirely. His junior associate, a young woman in a gray blazer who had said nothing since the hearing began, had stopped writing altogether. She was looking at her hands. Derek was looking at Margaret, not at me. He had not looked at me since he sat down. He was looking at Margaret the way you look at someone delivering news you cannot interrupt, with the fixed, slightly unfocused attention of a man who is hearing and not yet processing, whose mind is running a calculation that keeps returning an impossible result. Margaret reached the section on professional standing. She read the commendation letters into the record. 3 of them from judges whose names carried weight in this building and in every courthouse in the Northern District. She read them without theater, each one a paragraph, each one. Such specific, each one describing a version of me that I recognized as accurate and that I suspected Derek had never considered as real. When she finished, the room held a particular quality of silence. Grant rose for cross. He was good. I want to be fair about this. He was a skilled attorney in a very difficult position, and he conducted himself with more composure than the situation probably warranted. He focused on the years of reduced caseload, which was the only territory left to him. He was precise about dates. He asked Margaret to confirm specific years when my documented income had been lower than Derek's. She confirmed them. He asked whether during those years the household expenses had been primarily supported by Derek's income. She said, "Partially, miss." She caught herself, adjusted the adjustment itself, carrying information. Your Honor's income during those years, while reduced, continued to contribute to the household. The financial records reflect this. Grant said, but Mr. the petitioner's income was the primary income during that period. Margaret said, for approximately 31 months out of a 132-month marriage, yes. Grant paused. He had wanted a simpler answer. He did not get one. He asked 2 more questions, both of which produced answers that complicated rather than supported his position. And then he sat down with the controlled movement of a man who knows when a line of questioning has stopped helping him. I made a note. The hearing proceeded. Derek's turn came at 10:23 a.m. Grant walked him through the petitioner's narrative. The move to Atlanta, his business growth, the years he had provided the primary financial structure of the household. Derek answered in the measured way a prepared client answers, not robotically but carefully, with the awareness of a man who has been coached and is trying to remember the coaching without showing the effort. He was composed. I gave him that. He did not look at me. I let him answer 3 questions before I intervened, not to disrupt, to clarify. There was a factual inconsistency in his 3rd answer regarding the timeline of the Atlanta move that affected the asset calculation, and clarifying it was my function as the presiding officer, not a choice. I said, "Mr. Crawford." He looked up. It was the first time our eyes had met since I walked in. I want to describe what I saw accurately without adding to it. What I saw was a man trying very hard to be somewhere that was not in front of me. His jaw was set. The muscles along his temples were doing something tight and controlled. His hands were flat on the table in a way that suggested deliberate placement. He had put them there and was keeping them there. I said, "You stated the relocation to Atlanta occurred in the spring of 2013. The financial records submitted by both parties indicate the household was established in Atlanta in November of 2012. Which date is accurate?" A pause. He said, "November." I misspoke. I said, "Thank you. The record will reflect November 2012. I looked at Grant. "Counselor, the asset valuation timeline in your Exhibit 3 will need to be adjusted accordingly. That affects the calculation on the Cascade Heights property by approximately 19 months. Grant said, "Understood, Your Honor." I made the note. I did not look at Derek again for 11 minutes. At 10:51, Grant called a character witness, a business associate of Derek's, a man named Philip Osei, who had known Derek for 8 years and spoke to his professional integrity and financial acumen with the careful enthusiasm of a man who had been told to be enthusiastic, but not too much. He was on the stand for 6 minutes. Margaret declined to cross. At 11:04, Grant moved to submit Derek's financial exhibits. I admitted them. I noted 2 discrepancies in the documentation and requested supplemental clarification within 5 business days. Grant noted the request. At 11:22, Margaret called her first witness. Her name was Dr. Constance Webb. She was an economist at Georgia State, a specialist in household labor valuation and the economic contribution of non-primary earners in dual-income marriages. She had published 4 peer-reviewed papers on the subject. She had testified as an expert in 31 proceedings. She was 63 years old, and she wore reading glasses on a chain. And she answered every question in the exact number of words the question required, not one more. She testified for 22 minutes. By the end of it, Grant had objected 7 times. I had sustained 2 of those objections and overruled 5. Each overruled objection landed in the room with the quiet specificity of a door being closed. Derek's leg was moving under the table, just slightly. The kind of movement that happens when a body is managing something the face is refusing to show. I noticed. I noted nothing. At 11:47, Margaret submitted her financial exhibits. Among them was a document I had not reviewed in advance. She had prepared it without discussing it with me correctly because it would have been inappropriate for me to have seen it. It was a summary of the household's equity position over the full course of the marriage, cross-referenced with each party's income contribution by year. The total was on the last page. It was specific to the dollar. I heard Derek's attorney's pen stop moving. I reviewed the document for the appropriate amount of time. I admitted it into evidence. I set it aside. "Counselor Holloway," I said. "Do you have additional witnesses?" Margaret said. "No, Your Honor. The respondent rests." I looked at Grant. "Counselor Hollister, do you wish to call additional witnesses, or shall we proceed to closing arguments?" Grant leaned toward Derek. A whispered exchange, 30 seconds, the kind of exchange that compresses a significant amount of reassessment into a very small amount of time. Grant straightened. He said, "Your Honor, the petitioner would request a brief recess before closing arguments." I looked at the clock. "We'll take 15 minutes, I said. We reconvene at 12:15. I stood. The room stood. I walked back toward Chambers without looking at the gallery, without looking at the table on the right, without looking at anything except the door I was walking toward. In Chambers, I poured a glass of water, and I drank it standing at the window. Patricia knocked after 3 minutes with a message from the Chief Judge's clerk, a scheduling matter for next week. I handled it in 2 sentences and sent her back. I stood at the window. The parking lot was busier now, midday arrivals crossing toward the entrance. Ordinary people. A woman in a yellow coat arguing gently with a parking meter. A man in a suit eating a sandwich on the hood of his car with the specific determination of someone who has given himself exactly this long to eat. I thought about the document. The total on the last page. Not with satisfaction, not yet. With the specific recognition of someone who has spent 11 years building something quietly in the margins, in the hours before and after, in a man who thought he already knew the ending, and who is now watching the ending arrive. I set down the glass. I straightened the robe, and I walked back out. Grant Hollister was a good attorney. I want to say that one more time before I describe what happened in the next 40 minutes, because fairness requires it. He was skilled, he was composed, and he had been handed a case whose foundational premise had collapsed somewhere between the assignment notification and the moment I walked through the courtroom door. What he did with closing arguments under those circumstances was, professionally speaking, respectable. It was not enough. He opened by acknowledging the financial disclosure directly, not burying it, not pretending it hadn't happened, which would have been worse. He said, "The petitioner does not dispute Your Honor's professional accomplishments or standing." He said it cleanly, without visible pain, and then he pivoted to the only ground left to him, the 31 months. The period of reduced income. The years when Derek's salary had carried the primary household weight, when the mortgage and the utilities and the groceries had moved through his accounts in a way that was documented and quantifiable. He was precise about the numbers. He gave them slowly, letting them accumulate. It was competent work. When he finished, I made a note. I looked at Margaret. She stood. Margaret Holloway's closing argument was 4 minutes and 17 seconds long. I know because I have a habit of timing arguments in my head, a reflex from years on the bench, the same way some people count stairs without meaning to. She did not raise her voice once. She began with the timeline. Not Derek's timeline, the full timeline. 132 months of marriage. She spoke about each phase the way you speak about weather systems, factually, without drama, with the understanding that the facts themselves were sufficient. She named the years Ava had reduced her caseload. She named the reason Derek's request, documented in a series of text messages that had been submitted as Exhibit 14, and that I had read 3 times during the proceedings. Then she said something I had not expected. She said, "The petitioner's counsel has argued dependency. The respondent would like to offer a different word. Investment." She let it sit. 11 years ago, the respondent made a professional decision that cost her a federal appointment in Washington, D.C. She made that decision within the context of a marriage, in support of a partnership she believed to be mutual. She did not stop working. She did not stop building. She simply built more quietly than her husband noticed. A pause. The respondent would submit that the petitioner's failure to notice does not constitute a financial claim. The room was very still. Grant did not object. There was nothing to object to. Margaret sat down. I made a note. I looked at both tables. "Thank you, counselors," I said. "I will take this matter under advisement and issue a written ruling within the standard time frame. However, given the factual clarifications made during these proceedings, I want to address several items on the record before we adjourn." I looked at my notes. First, the Exhibit 3 timeline discrepancy. The asset calculation on the Cascade Heights property will be corrected to reflect the November 2012 establishment date. This affects the equity valuation. Counselor Hollister, your office will need to resubmit the corrected figures within 5 business days. Grant said, "Understood, Your Honor." Second, the characterization of the respondent's employment history in the amended petition. The term used was professional dormancy. The record does not support this characterization. The respondent maintained active professional standing throughout the marriage, including a judicial appointment that has been in effect for 3 years. The court will not be incorporating that language into its analysis. A silence. I did not look at Derek. Third, and I want to be precise here, the motion for recusal submitted this morning. I denied it on procedural grounds, and I want to be clear about why. The basis for a recusal claim under Georgia Code Section January 8, 15 requires demonstrated prejudice or a financial conflict of interest. A personal relationship that is itself the subject of the proceeding does not automatically constitute grounds. It requires something more. I set my pen down. I have presided over this hearing with the same standard I apply to every matter before this court. The record will reflect that. I looked up. The room was quiet in the way a room gets quiet when everyone in it is very carefully not reacting. Grant said, "The petitioner appreciates the clarification, Your Honor." I said, "I'm not offering it for the petitioner's appreciation, Counselor. I'm offering it for the record." A beat. "Yes, Your Honor." I gathered my notes. And then something happened that I had not planned and had not anticipated, and that I would think about for a long time afterward. Derek spoke, not to Grant, not through proper channels, not with his hand raised or with any of the procedural framing that transforms an outburst into a recognized contribution. He simply spoke from his chair in the voice of a man who had been holding something in for 3 hours and had run out of room. He said, "How long?" Not a question exactly. The grammatical structure of a question without the inflection of one. Flat, direct. The 2 words of a man trying to locate the beginning of something he had badly miscalculated. The room tensed. Grant put his hand on Derek's arm. I looked at Derek for the first time since 10:23 a.m. I said, "Mr. Crawford, you are represented by counsel. If you have a statement for the record, how long have you been a judge?" Grant said, "Derek." "I'm asking her." The room was very, very still. I held his gaze. I did not look away, and I did not soften, and I did not give him anything that could be read as an invitation to continue. But I answered. I answered because the question, stripped of its context, stripped of its specific gravity in this specific room, was a reasonable question, and because I've always believed that reasonable questions deserve answers, even when the asking of them is poorly timed. I said, 7 years in Georgia, 3 at the federal level. He stared at me. I said, "Is there anything further for the record, Mr. Crawford?" His mouth opened. Something moved across his face, not anger, exactly, not grief, exactly, something that was made of both of those things, and of something older and harder to name. Something that lives in the space between who you thought a person was and who they have always been. He said nothing. Grant said, "Nothing further, Your Honor." I said, "Then we're adjourned." I stood. The room stood. I walked toward the door without looking back, and the bailiff opened it, and I walked through it, and the door closed behind me, and I stood in the corridor for exactly 3 seconds, with my hand flat against the wall, feeling the specific texture of painted concrete. Under my palm, the specific temperature of a building that has been absorbing the weight of human decisions for decades. 3 seconds. Then I walked back towards Chambers. Patricia was at her desk. She looked up. She had the particular expression of a young person who has witnessed something significant and is trying to determine whether it is appropriate to acknowledge it. I said, "Clear my 2 o'clock if you can. I need time to draft the preliminary findings." She said, "Yes, Your Honor." I went into Chambers and I closed the door, and I sat at my desk, and I put both hands flat on the surface, and I breathed. The robe was heavy in the way it was always heavy, not uncomfortably, but with the specific weight of something that matters the weight of accountability, the weight Judge Okafor had described to me 20 years ago, and that I had carried imperfectly but consistently ever since. My phone was on the desk. It had been off since 8:45 a.m. I turned it on. 11 messages. 8 from numbers. I recognized colleagues Patricia from her personal phone, attesting something about the docket my mother who called every Thursday without fail. 2 from Margaret sent during the recess, both marked routine. And 1 from a number I did not recognize sent at 11:58 a.m. during the 15-minute break. I opened it. It was from Sienna. It said I saw the courthouse notification. I didn't know who you were. I want you to know I'm sorry. I read it twice. I set the phone down. I looked at the wall. Then I looked at the window, at the gray Atlanta sky beyond it, at the parking lot that was almost full now, at the ordinary Thursday afternoon, assembling itself outside a building where 3 floors below me, a man was sitting in a wooden chair, trying to locate the version of events he had been living in, and finding it was no longer where he had left it. I picked up my pen. I began to write. The ruling took me 4 days to write. Not because the legal analysis was complex, it wasn't not particularly, the facts were well documented, and the applicable statutes were clear. It took 4 days because I wrote it 3 times. The first version was correct, but too spare, the kind of ruling that says what it needs to say, and nothing more, which is usually what I aim for. The second version overcorrected, adding context that was explanatory rather than legal. The kind of writing you produce when you are too close to something, and your mind keeps reaching for justification, where justification is not required. The third version was right. I sent it to Patricia on a Sunday evening. She formatted it and filed it Monday morning. By 10 a.m., it had been transmitted to both parties' counsel. I was on the bench when my phone buzzed in chambers. I did not read the messages until 2 p.m. The ruling was what the evidence required. The Cascade Heights house would be sold, the proceeds divided according to a formula that accounted for the full 132 months of marriage, not the 31 that Grant had tried to make definitive. My professional income was recognized in its entirety, 7 years of Georgia salary, 3 years of federal. And the asset division reflected it. Derek received what the law entitled him to, not more. The amended petition's characterization of dependency was noted in the ruling's language with the specific word I had chosen carefully, unsupported. Margaret called it 247. She said, "It's a fair ruling." I said, "It's the correct ruling." She said, "Those aren't always the same thing." I said, "No, but in this case, they are." A pause. She said, "He's going to appeal?" I said, "On what grounds?" Another pause shorter. She said, "I don't know yet. But Grant will find something to file, because filing something is what you do when your client needs to feel like it's not over." I said, "Let him file." She said, "You're not worried." I said, "I'm not worried." She said, "All right then." We talked for 3 more minutes about the supplemental filing timeline, and then she said goodbye, and I put the phone down and went back to the brief I'd been reading. Grant filed a motion for reconsideration 8 days later. It was, professionally speaking, thin. It reiterated the recusal argument with slightly different language, raised a procedural objection to the admission of Dr. Webb's testimony that had not been raised during the hearing, a significant problem for its validity, and included a 2-page section on the asset calculation that contained a mathematical error I identified in the first reading. I noted the error in my response and denied the motion within the standard time frame. The error did not appear in any subsequent filing. What I had not anticipated was Atlanta. The legal community in this city is smaller than it appears from the outside. Smaller in the ways that matter, the ways that involve reputation and professional standing, and the particular social infrastructure of people who work in the same buildings and appear before the same benches and see each other at the same bar association events twice a year. I had understood this when I moved here. I had understood it more deeply over the years. What I had not fully modeled was the speed. I became aware of it on a Wednesday, 12 days after the hearing, when a colleague, Judge Terrence Walcott, family law, 15 years on the bench, a man of almost geological composure, stopped me in the courthouse corridor and said without preamble, "I heard about the Crawford matter." I said it was a routine civil proceeding. He looked at me with the expression of a man who finds this characterization interesting. He said, "Ava, half the building heard about it by Thursday afternoon." I said nothing. He said, "For what it's worth, and I'm saying this as a colleague, not as anything else, the way you handled it was correct. Everything about the way you handled it was correct." I said, "I know." He nodded. He walked away. I stood in the corridor for a moment. Then I went back to work. The specifics of what circulated I learned in pieces, not because I sought the information out, but because Atlanta being Atlanta, it arrived whether or not you went looking for it. The audio from the courtroom proceedings had been requested under Georgia's open records law by an attorney who had heard something from someone who had been present in the building. The request was legitimate. The audio was provided. It was not as Margaret explained carefully when she called to tell me the kind of audio that required any action on my part, because I had done nothing irregular and the record was exactly what it was. But audio travels. By the third week after the hearing, the exchange, my denial of the recusal motion, the question and answer about case law, the specific phrase, "Do you have grounds or do you have feelings?" had been shared in a group chat among Atlanta litigators that I knew existed and had never been part of. Margaret told me this with the tone of someone delivering news they find privately amusing, but are managing professionally. I said, "Is there anything I need to address?" She said, "No." I said, "Then I won't." Derek's professional consequences arrived not from the audio, but from a different direction, and arrived more quietly than I would have expected. He had been in late-stage negotiations with a commercial development firm based in Charlotte, a partnership that would have substantially expanded his Atlanta operation, the kind of deal that had been building for 8 months. And that he had mentioned in the particular way he had of mentioning his professional victories more than once over the previous year. I knew about it the way you know about weather in a city you used to live in residually without effort. The deal did not close. I learned this through Margaret, who learned it through the specific information channels that exist in a city where everyone is connected to everyone by at most 2 professional relationships. The firm in Charlotte had conducted their standard due diligence before finalizing the partnership. Due diligence in this context included a review of recent public legal proceedings involving principles of the partnership. The hearing was a public record. The ruling was a public record. The characterization of Derek's amended petition, specifically the word unsupported, specifically the correction of the dependency narrative on the record, was a public record. A firm considering a significant partnership with a man had read all of it. They had made a business decision. I did not feel satisfaction when I heard this. I want to be precise about that, because satisfaction would imply that I had wanted this outcome, that I had built toward it, that somewhere in the 4 days I spent writing that ruling, I had been thinking about Charlotte. I had not been thinking about Charlotte. I had been thinking about the evidence and the statute and the correct application of one to the other. The consequences of accuracy are not the same thing as revenge. I thought about this at some length. Sienna sent one more message 9 days after the first one. It was longer than the first 3 paragraphs, careful the kind of writing a person does when they have drafted something multiple times. She said she had not known about the marriage in the way she would have needed to know to make a different decision. She said she understood if I had no interest in responding. She said she was sorry again, in different words. I read it twice. I did not respond. Not from anger. I want to be clear about this too. The anger, whatever portion of it had been directed at Sienna, had never been the largest portion. And it had metabolized in the months between January and the hearing, into something smaller and less urgent. What I felt reading her message was closer to exhaustion than anything else. The particular exhaustion of a situation that has required a great deal of energy and is finally incrementally releasing you. I set the phone down. I went home that evening, and I walked through the house that was still technically mine for another 60 days, while the sale processed, and I moved through it with a different quality of attention than I had in months, not the careful attention of someone preserving something, but the open attention of someone who is beginning slowly to think about what comes next. The magnolia tree had bloomed. I had almost missed it the week of the hearing, the week of the ruling, the weeks of the motion, and the response, the weeks of Atlanta being Atlanta. But it was there when I walked into the backyard on a Tuesday evening with a glass of water-white flowers against the gray sky earlier than usual this year, unannounced, not waiting for anyone to notice. I stood under it for a while. The flowers were very white. The sky behind them was the specific gray of Atlanta in early spring, the kind of gray that is not threatening, but is not yet warm. The gray of a season that is genuinely undecided. I did not feel triumphant. I felt for the first time in a long time like myself, not the self that had adjusted and reduced and moved quietly through a life built around someone else's comfort, not the self that had learned to exist in 2 registers at once and had mistaken the skill for the solution, the self that had walked into a courtroom at 9 a.m. on a Thursday morning and sat down behind a bench and looked out at a room and done her job. That self, that had always been the one that mattered. I finished my water. I went inside. I had an early morning. The house sold in 19 days. The buyers were a young couple, late 20s, first home. The wife was an architect, and the husband taught high school history. And they had the particular energy of people who are about to do something that will matter for the rest of their lives, and know it. Their agent sent over a handwritten note with the offer. I read it once, set it aside, and told Margaret to accept. I did not attend the closing. I had already said goodbye to the house. In the way that mattered, not in a single moment, not with ceremony, but in the accumulated ordinary mornings of the last 60 days. The coffee, the kitchen window, the particular quality of silence on a Sunday when the city is still deciding whether to wake up. I had moved through all of it deliberately and without rushing the way you finish reading a book you have loved and are not going to read again, completely carefully honoring what it was without pretending it is something it is not anymore. The magnolia tree stayed with the house. I had asked Margaret about it half seriously during one of our calls, whether a tree could be written into a sale agreement. She had been quiet for a moment, and then said, "Ava," in the tone she used when she thought I was being impractical, and I had said, "Never mind," and we had moved on. But I thought about it sometimes. I thought about the architect and the history teacher and their mornings in that backyard, and the tree blooming for them in March, without explanation, without introduction, just arriving the way it always had. I moved into an apartment in Inman Park in April, 7th floor. Large windows facing east. A kitchen smaller than the one I had left, but with better light. No yard. A balcony just wide enough for 2 chairs and a small table, which was all I needed, which was, I was learning the correct amount. My mother came for a weekend in May, and she walked through every room twice. And then she stood in the kitchen with her hands on the counter and said, "This is yours," with the particular emphasis of a woman who has watched her daughter inhabit other people's spaces for 11 years. I said, "I know." She said, "I mean it, Ava." I said, "Mom, I know." She made tea. We sat on the balcony until it got dark. She did not ask about Derek. She did not ask about the hearing. She asked about my cases, about my clerk, Patricia, who she had heard about and approved of without meeting, about a documentary she had been watching about underwater ecosystems that she thought I would like. We talked until 9 p.m., and then she went to bed in the spare room, and I sat on the balcony alone for another hour. and listened to Inman Park, doing what Inman Park does on a Saturday night, the particular ambient sound of a neighborhood that is alive and not asking anything of you. I had not understood, until I was sitting in it, how much I had needed silence that did not require management. Work continued. It always continues. There is something reliable about the docket that fills regardless of what is happening in your personal life. The cases that arrive carrying their own weight and their own necessity, entirely indifferent to what you were doing before you walked through the door. I have always found comfort in this. Some people find it dehumanizing, the institutional indifference of a building that keeps processing human problems, whether or not you are whole enough to process them with it. I have always found it clarifying. The work does not ask how you are. It asks what you see. It asks what the evidence shows. It asks what the law requires. Those are questions I know how to answer. Patricia left at the end of June to clerk for a 11th Circuit judge, a position she had earned, and that I had written a letter for without being asked, because it was the right next step for her, and because good people should move toward the things they are built for. She came to my chambers the day before her last day with a card signed by everyone on the floor, and a small plant she said was low maintenance, which I appreciated. I told her she was going to be excellent. She said she was nervous. I said that was correct. She laughed. She left. I kept the plant on my windowsill. It has been alive for 4 months, which I take as evidence of something, though I am not certain what. The appeal Grant filed was denied in September, a single paragraph from a 3-judge panel, efficient, and without comment, the way denials are, when there is nothing there to argue about. Margaret called to tell me. I thanked her. We talked briefly about a family law matter she was handling that had a procedural question she wanted my perspective on. Not as my attorney, just as a colleague, the way these conversations happen in a city where everyone knows everyone. We talked for 12 minutes. We made no plans to speak again, but we both understood we would. I did not hear from Derek. Not directly. Not through counsel. Not through the specific Atlanta proximity that had made information move so fast in those weeks after the hearing. He existed somewhere in the city. I knew this, the way you know the weather, in a place you no longer live distantly without stakes. And he was getting on with whatever came next for him, which was his business and not mine. It had not been mine for longer than the paperwork officially reflected. I thought about him less than I expected to. Not because the marriage had not been real. It had been real in the way that 11 years of anything is real, woven into your daily habits and your interior vocabulary, and the 1,000 unremarkable ways a shared life restructures you without your permission. I thought about him less because the part of me that had been waiting for the other shoe, waiting for the next maneuver, waiting, with the particular vigilance of a woman who had spent years anticipating the emotional weather of a man who ran warm and cold, without warning that part had gone quiet. There was a lot of room in the quiet. I started running again. Early mornings before the courthouse, through Inman Park and down toward Freedom Parkway and back, 40 minutes my own company, and the specific quality of Atlanta light at 6 a.m. Low and golden and honest, the light of a city that has not yet decided to perform itself. I had run in my 20s and stopped when the marriage filled the mornings with other requirements. Starting again felt less like reclamation than like returning to a conversation I'd not finished. My body remembered it. That was the right word, not relearned remembered. I had a conversation in October with Judge Okafor. She was in Atlanta for a conference. She had moved from D.C. to a senior position on the 4th Circuit years ago, but still traveled, still lectured, still corrected people's grammar in the margins of their work with the same expectation of gratitude. We had coffee in the lobby of her hotel 2 hours on a Wednesday afternoon. The kind of conversation that compresses years into a short space, because the two people in it have been having the same conversation in installments for 2 decades. At some point, she asked how I was. I said, better than I expected. She looked at me over her coffee cup. She had a specific look, not quite approving, not quite skeptical, something between the two, that I had spent years trying to earn a response to. She said, "You know what the error was." It was not a question. I said, "I made myself small so he would feel large." She said, "And?" I said, "And the smallness was supposed to be temporary, and it wasn't." She nodded once. "The robe was always there," she said. "You just stopped wearing it at home." I sat with that for a moment. She said, "Don't do that again." I said, "I won't." She looked at me. I said, "I mean it." She picked up her coffee. "I know you do." We talked for another 40 minutes about the 11th Circuit and about a case she was following and about her granddaughter, who was 9 years old, and had recently informed the family that she intended to be a marine biologist or a senator. And Judge Okafor had told her those were not mutually exclusive, which I thought was correct. When we said goodbye in the lobby, she held my hand for a moment, not long, just a moment, the specific warmth of a woman who does not dispense warmth carelessly, and she said, "You did good work, Ava." I said, "I did the right work." She smiled. She walked toward the elevator. I stood in the lobby for a moment. Then I walked out, there into the October afternoon, Atlanta in fall, the air finally doing what fall air is supposed to do, cool and direct, and carrying the smell of something ending cleanly. I had a 4 p.m. hearing. I walked back toward the courthouse, past the parking meters and the lunch crowd thinning out, and the woman in the yellow coat I'd seen from my window months ago, or someone who looked like her, arguing gently with a phone now instead of a meter. The city doing what cities do, continuing. I thought about the courtroom, about the Thursday morning in February when I had walked through a door and sat down behind a bench and looked out at a room where a man was smiling at a joke he thought was already over. I thought about the 4 seconds I had watched him before the bailiff spoke. I thought about what I had felt, not triumph, not anger, not the satisfaction of a long-prepared conclusion arriving on schedule. What I had felt was simple. I had felt like a woman who knew who she was sitting in the room where that knowledge was most legible on the day it happened to matter most. That is not a small thing. In the years I had spent adjusting and managing and moving through a life that had slowly, incrementally asked me to be less than I was in all of those years, the thing I had held on to imperfectly but consistently was the knowledge of what I was when I was most fully myself. Not the version that came home and made dinner, not the version that reduced the caseload and changed the address on the correspondence and learned to exist in 2 registers at once. The version that put on the robe. I had never let that version go entirely. That was the thing that mattered. Not the hearing, not the ruling, not the word unsupported on page 7 of a legal document. Not the Charlotte deal that didn't close, not the audio that circulated in an Atlanta group chat. Those were consequences. Consequences are not the point. The point is what you hold on to when a life asks you to put it down. The point is the folder in the desk drawer. The point is knowing even in the years when you were not wearing it exactly where the robe was. Here is what I want to leave with you. We spend a great deal of energy managing other people's comfort, adjusting our volume, our ambition, our visibility, calibrating ourselves to the emotional weather of rooms and relationships until the calibration becomes habit and the habit becomes invisible. And one day, you reach for yourself and find you have misplaced the most essential parts. Do not misplace the most essential parts. The version of you that is most fully, most completely, most irreducibly you. That version does not need to announce itself. It does not need to perform. It does not need to be understood by people who have decided not to look. But it needs to exist. It needs to be tended. It needs to be somewhere you can find it on a Thursday morning in February when you are 20 feet from a man who has decided the story is already over. Because sometimes the most powerful thing you can do is simply walk into the room, in the robe you have always owned, and sit down.